Welcome to Business Talk with Megan McNulty, the podcast that takes you behind the scenes of business success and reveals the strategies, insights, and stories that drive these professionals to thrive in the ever-evolving world of business. Whether you're an established entrepreneur, a seasoned business owner, or simply fascinated by the world of commerce, this podcast is your front row seat to learn from the best. Each episode, Megan will bring you engaging interviews with professionals from diverse industries who will share their triumphs, lessons learned, and the insights they've gained along the way.
Hi, Janine. How are you today?
I'm good. How are you doing?
Good. Thanks for talking with us about probate litigation. I guess I just want to kind of start off, letting the audience know basically, why we want to talk about probate litigation. It's crazy. I feel like people don't understand that why they need a will or trust, or, if they don't actually do any planning ahead of time, that their family or their loved ones are going to end up in probate court. And probably next to family law, it's probably the most contentious form of litigation, which you practice. And so wanted to have a discussion with you about it today so people kind of understood what probate is. And I don't know if you can be able to explain what probate is and what typically occurs, because I really feel like the general population, unless they've gone through it, doesn't really know.
Sure, absolutely. So probate is the court process that is required when somebody dies and they had assets that typically were just in their individual name. So they didn't have any joint owner on it or no beneficiaries on it, or more importantly, that they didn't have a trust with their assets in a trust. So probate strictly is the court process when somebody dies in that circumstance. Their assets would have to go through the court system if they didn't have the planning and have their assets in a trust or some other protective measures in place. Probate litigation is when assets are going through the court system, or potentially if there was a trust involved and people are fighting over those assets, all of those fights that have to do with the assets of somebody after they've died go through the probate court.
Wonderful. So in some of these probate cases, what do you disputes or issues commonly arise? Like, what's the most common thing you see?
So, the most common complaint about just general probate is just how long it takes and how expensive it is. But outside of that, the issues that develop are oftentimes, first, who's going to be in charge of things. So if somebody didn't have a trust or any kind of planning in place, then the law says who has the right to be the administrator, or what oftentimes people think of as the executor of the estate. And that's a lot of the time where issues come up. So, usually it's the surviving spouse has first priority, and then any kids have next priority, and it goes on from there. But in some cases where we have multiple kids, for example, then there can be issues among there that one of them is taking the reins and trying to file it and get put in charge, but the other one or other ones don't want that person in charge. And so then now we're in a potential fight over who's going to be in charge because this person doesn't want that person in charge. So that's probably the most common issue. The other one would be accounting. So whoever gets put in charge is the one who holds the purse strings and is responsible for taking over the assets, paying the expenses, and handling the assets however they say is appropriate. And they do have a fiduciary duty, so they have to handle that properly, but still, some of those decisions other people just don't like, or they just don't like that person and don't agree with some of the decisions they made. So generally on the accounting, where we are reporting what's happened with the assets, that's the other big area where we see potential issues come up.
That makes sense. Because maybe some family members aren't happy at how slowly or quickly they moved and what was paid for and what was reimbursed. I could see fighting over that situation. What when you get these cases, how do you decide who you represent? Like if you take on a probate litigation case?
So, we are typically getting calls from somebody who either wants to get appointed as the administrator or is appointed in some kind of document and don't know what to do. and they are just needing some guidance on what they need to do and how they need to do it. In some other litigation cases, it's that we're getting calls because somebody is unhappy with somebody else who is in charge and they're not doing things right, or, you know, similarly, that they're not doing anything, that it's been a certain amount of time and they're not getting any information and they're not getting any communication and they're not think that nothing's happening. So those are very often the calls we get. Frankly, it's a lot of fact finding. And sometimes we don't really get to the bottom of it until we've really dug into a lot of the documents, depending on the situation. If it's as straightforward as somebody's just trying to become appointed as the administrator over an estate, then we just go into what is their priority? What's the situation? You know, did this person have a spouse when they died? Did they have kids? How many kids are there? What are the relationships? So we get into that so that we know who has the priority, because we deal with that every day and we have it memorized. For example, what we see sometimes is that somebody will be the child of a decedent, but their parent had gotten married, you know, relatively recently. Maybe it's not their other parent, but there is a surviving spouse. And in that particular case, if there was no planning involved, that surviving spouse has priority. So in that particular situation, we would explain to that person that, you know, they probably shouldn't petition to be the administrator because they don't have priority. And we maybe wouldn't take that case. But if it's people on an equal playing field, then it doesn't matter who petitions to try and be administrator.
Okay. Can you like provide examples of challenging probate cases you've handled that maybe we might find interesting?
Yeah, so I would say the most challenging one I have right now is actually, it's a really sad situation. It's a really common situation where there was a trust, and there's one son who was put trustee of the trust. At this point, it's been a little over 1.5 years since the mom died, and we have been requesting that he provide information on the assets of the trust for over 6 months, and he's just not providing any information. So, well, long story short, he's supposed to be giving an accounting to the beneficiaries at least at the 1 year mark, and he hasn't done it. And so ultimately we have no choice but to petition for his removal as trustee. And with that, as we geared up for that, we found a bunch of documentation. We were able to dig in. He finally got an attorney who's at least responding to us and has given us some information. With that information, we've found hundreds of thousands of dollars that he's essentially just mismanaged. But the way he's done it is super clever. So this guy's very clever, but just from the information that he sent us, we can see where he's wrongfully done stuff. And we have some statements that don't match the information he's sending us. And it's just a complicated mess as far as what has happened with the assets over the last 1.5 years. And that's really what the fight's going to be about, but it's going to be a big fight. And then another one that I have that we actually just recently settled last week is where their mom's deceased. We're in contact with the mom's kids, but mom was married, and this was her second marriage. And she got married when the kids were much older. So, you know, later in life marriage, she already had her property long before she married him. And he was never on the property, specifically signed away his interest in the property. She died. He lived there. He refuses to leave the property, refuses to sell it, says he's going to live there forever and there's nothing the kids can do. So we went into a 2-year court battle over trying to get him to understand that he's not entitled to this entire property because it was her separate property, was never a community property interest, and that he doesn't get to just sit there and live there forever without the kids getting any value out of this property. So, but since he was the surviving spouse, he does have some power and some rights. And we had to essentially show how he's mishandling things so that he doesn't get appointed the administrator. So that's another one that was kind of complicated because it was a bit of a fight, but we thankfully got him to realize that part and settle that one last week.
Okay. Wow. Good. Yeah. Cause it's for the family members. It's tough if they're not the administrator or the trustee. They kind of don't have control over how quickly everything moves and the funds and how the money is being managed. So I could see that. Yeah. Like the first case you mentioned, the probate process, I also think people don't realize can be very lengthy. So it could take anywhere from a year to 2 years potentially. How do you communicate with your clients like throughout that process? Are most people aware that it takes that long? Does it ever move faster?
Yeah, so I usually say the average time for a probate case in California is a year. And I will say that is with a happy family and a very straightforward probate. It does take about a year to get through. Every county is a little bit different on their timelines and requirements. And can we expedite some things here and there? Every county is a little bit different. So I'd say that a good rule of thumb is about a year. It is absolutely something that we tell all of our clients in our consultation and remind them throughout. However, that does not change the fact that it's the number one complaint that we get. It's the number one complaint of what's taking so long, what's taking so long. Then we constantly have to remind them that we're waiting on the court. And the hardest part is that usually we get approval pretty quickly and authority for somebody to handle the assets and, sell a property, if that's usually what we're dealing with. So they sell a property, we're still in probate, the money's now in the probate estate, and then we have to still go through the motions of court, and we have to have a final accounting and a final hearing. And the hardest part is that a lot of the counties are setting those hearings out 4 months, 6 months, 8 months out. So then there's that waiting period where we're just sitting there waiting on our hearing date to get the approval for all of the work that's already been done. That's the biggest complaint we get, is that part of it. When they feel like they've done all the work, they're ready to just distribute, but now we just have to sit there and wait for the court hearing to get approval for that distribution.
Yeah, wow. How do you resolve actually, let's rephrase the question. Can you resolve these probate disputes outside of court ever, or are there strategies?
Yeah, any legal battle, I definitely hear like anything can be resolved without having to go through full litigation. And most of them do get resolved. I will say the one that we settled last week, I never thought that case was going to settle. And lo and behold, it got there. So yeah, I would say the most common way is through mediation. And again, every case or every county has a different way of handling it. Some counties will have mandatory settlement conferences where if you're headed toward trial and we've set trial date, they'll also send you to mandatory settlement conference where you will get together and see if we can essentially settle it before we go to full trial. Other counties like Riverside County has a specific program with the Riverside County Bar Association where they'll give you 3 hours of free mediation if everybody agrees to do that. And that's how this last one settled, that we were like, sure, let's give it a try. Again, I did not think it was going to be possible, but we settled. So usually it's mediation is how it gets handled, but there are different programs that different counties have. The MSCs in Orange County, for example, everybody has to have an MSC and it doesn't cost money. Otherwise, there's private mediation. So there's a new thing in probate where the judge can require everybody to go to mediation. So if the judge feels that the case is ripe for mediation and thinks that, okay, there's just a few minor issues here that the parties are not getting along on, the court will instill what's called a Breslin order, where they will require that everybody attend mediation. And it's a great tool. We do have a couple of judges who are just sending everybody to this mandatory mediation, and that can be a little bit difficult if we're not anywhere close to being settled. But typically, yeah, it's some form of mediation, whether that's through the county's specific program that they have or private mediation.
Interesting. How much does mediation cost?
Well, that's different across the board. So, on like the Riverside program, for example, it's 3 hours free. So it's 3 hours free through their program that they have. And then you can go beyond that. And then it's essentially depends on what the mediator's rate is. So that's with private mediation, it depends on your mediator because every mediator has a different cost and rate. For a full day's mediation, I would say the total costs are probably around $10,000, give or take. And usually the parties split that cost. But yeah, for a private mediation where you're using like a retired judge or something, that's probably a ballpark figure of what a full day's mediation might be, just for the mediator, not the attorney's fees.
Wow. Okay. So does probate law or the regulations change constantly, or do they pretty much stay the same? How do you know if they change the law or regulations on probate, I guess?
So we actually get updates from the bench in the counties that we practice in. Every year we will have a meeting, like with the Orange County Bar Association. There's a meeting with the attorneys and the judges where they do roll out what has changed in the past year, if there are any new statutes, but more importantly, typically any cases that have come that further define things or to change some definitions of things. We've had some significant changes in conservatorship law, for example, since the Britney Spears case, and that was actually by statute. So yeah, things do change, and the courts are constantly changing their processes. So it depends on the county for that part of it, but that's how I would say is our first indication, is those updates from the bench where the probate judges specifically speak to the attorneys about what has changed recently in the courts and in the law. Besides that, it's our own educational resources that we continually go to as attorneys.
So you bring up, I wonder if you're okay talking about this. You brought up Britney Spears, and I was fascinated with that case. How is it that like she's a $multi million, teenage star and, into her 20s, and all of a sudden her dad was able to just like take over her estate, and all of her money, and tell her what to do and what medicine she has to take, and when she can and can't leave the house. How did her autonomy get taken away like that?
So, I have not gotten into the weeds of the Britney case. However, it's my understanding that when she went into a bit of a spiral, we all remember that when she shaved her head and everything, that's really when it came into play. And it's my understanding that she consented to the conservatorship. So if I had to guess, I would guess that it was some kind of conversation as a family of, okay, clearly something's going wrong, and here's your choices. We can do X, Y, or Z. This is an option where obviously you need some help here, and we're going to just hand off all of this stuff because obviously it's too much stress for you that's going down the wrong road. And I think she would have been agreeable to it at that point. The problem that happened is that it went on for so long, and I doubt she understood how much power she was actually giving to her father, because conservatorship typically is for incapacitated adults who need somebody to take over their entire life. Whereas she probably didn't really need somebody to take over her entire life, but maybe she needed some help here and there at that point. And so that's where I think it ended up kind of going wrong. And she didn't realize that this doesn't have to, A, continue my entire life, and B, it doesn't have to be every single facet of my life. So what the change has come from that is more of an advocate for those people to be able to get the conservatees, to get their own counsel and have their own attorneys of their liking and their decision to guide them of what their rights actually are, especially as time goes on. Because what would happen automatically in all cases is that the court would appoint an attorney for the conservatee. And everybody just took that at face value of, okay, this is my attorney. And I think what they ended up doing in that case is kind of guiding who was in those respective positions, and they all kind of worked together. And once she was able to get another attorney in there, that's when it got terminated.
Okay, so that was, because I was like, whoa, and she was able to make her case that she didn't need the conservatorship anymore, which is important. Interesting. I thought that was very fascinating. So, okay, now with this, when you're in court, when you're in probate litigation, I think, a lot of people, you're in probate because someone didn't plan, whoever died didn't have a plan, didn't have a will, didn't have a trust. And it always amazes me why people don't plan, because it's not that expensive to get a plan in place. How much does probate litigation cost?
Well, if we're just going through probate with no fighting at all, it's expensive, and it's set by statute. The reason it's expensive is because the attorney's fees are set by statute, and the administrator gets to collect the same fee that the attorney does. And it's on a tiered basis. It's based on the value of the estate. So it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and so on. I tell everybody it's similar to paying a realtor's commission.
Okay.
Sometimes people think, oh, I need to, it has to go through probate, and my house is worth $500,000, but there's a $300,000 mortgage on it. Well, it doesn't matter. Similarly to where if you were selling that property, it wouldn't be based on what the net value is and the proceeds you're getting out of it. It's based on the sale value. So it's the exact same through probate, and that's what makes it so expensive. Now, with the litigation cases, typically all of those, they're hourly. So whatever time goes into it is what ultimately it ends up costing.
Okay.
So it's really hard to ballpark. Usually I tell people, I would say, usually starts with a $10,000 retainer, but I always tell them that if it goes to full litigation, meaning that we go to trial and everything, it could be $100,000 or more to go to full litigation, and that they might need to plan spending a few $1,000s a month on litigation. It depends on the circumstance, but it is essentially, it's hourly. So whatever time goes into it, and depends on the case, it depends on the complexity of the case, how soon it settles, all of that.
Yeah, I mean, it can be like for like $1 million estate, it can be a lot of money.
Yeah, I mean, for a straightforward probate on a property that's worth $500,000, for example, no matter the mortgage on that, the probate fees on that are about $25,000 plus court costs. So just to give a rough figure of what just probate costs, and that's with nobody fighting.
Right. Okay, what advice do you typically give clients who are involved in probate disputes? Like, what's your first level of advice when you're talking to them?
Usually I am having to tell them, if they are in a dispute, typically with their siblings or some other kind of family members, what I'm constantly having to tell people is that what may be the truth and what may actually have happened is sometimes different than what we can prove in court. And that is really hard for people to come to terms with or understand, because if I'm getting a whole lot of my sister completely took advantage of my mom and didn't share anything with me and took all my mom's money, and my question will be, okay, so what have you seen that makes you say that she's taken all of your mom's money? And if the answer is just, oh, I just know it. That's how she's always been. She's always shut me out. She's always bullied me. Well, I can't take that to court. I can't go to court and tell the court, oh, she's always bullied her, so we know she took all the money. We have to prove that happened. So that's the number one thing I think we usually start with, is see what kind of homework they can do. What can we find? What kind of documentation can we find? So it's not a he said, she said game.
Okay, that makes sense. How hard is it to get someone removed? Okay, so let's say a family is fighting over who the trustee is of the trust, and all of a sudden now they want to fight in court over the trust matter. How hard is it to get the trustee removed?
I would say it's difficult. I don't think it's an easy thing to get a trustee removed. You definitely have to have proof. I will say the first thing we go to is, have they fulfilled their statutory requirements? Because there's so many people that just think they're going to do the trust admin themselves without getting an attorney, and that's fine in a happy family sometimes. But if there's a notice that has to be sent out when somebody dies, and nobody does that if they don't know to do that. And so that's where I start with, did they even send this particular notice? And then it also is, when did the decedent die? How long has it been? And have you gotten an accounting? The accounting is usually the big factor of it. And if it's been well over a year or multiple years and no accounting's been done, and an accounting has been requested from the trustee and they are not providing the accounting, then that can be grounds for removal. But honestly, even with that, if what happens a lot of the time is then the trustee then acts as soon as we file something, because now we're in court and now they know we're serious. So then they'll file the accounting then. And a lot of times we'll get judges that go, well, you got the accounting now, aren't you? You should be good. And sometimes that is all we're looking for. But I think it has to be some serious malfeasance with the funds to really get a trustee removed. Even delay of time isn't always enough. It needs to be that they've really misused the funds or mismanaged the assets in a great way.
Interesting. What about, do you see a lot of families fighting over like tangible items like pictures, furniture? Are there any ever big fights over stuff, I guess, tangible, physical items like that?
I hear that all the time. I will hear people coming to my office even to have a consult, and they'll talk about how they heard all these other cases where people are fighting over Tupperware and things like that. My answer in my experience is no. I don't see really many of those disputes at all. It could be because we're the attorneys, and, first of all of the attorneys in this field are so busy, and they're only going to take cases that you actually have a case. And it is extremely hard to fight over personal property items because there's no paper trail of ownership, and there's also no paper trail of value to those items. So no, we typically don't see any of those crazy fights about things that don't matter, because I think at the end of the day, people don't want to pay the attorneys to fight over those things that don't have a value.
Okay, right. I know you kind of hear about it and then you don't. What about some of these probate cases you hear of, like, celebrities that have been they're still in probate 10 years later? Why is that happening?
So with that, I think with the celebrities in those big estates, I think the problem with those comes where they're trying to find heirs or trying to find different complicated tax issues and rights to the different things that may be evolved that are going to keep going on and on and on. For musicians, for example, the rights to all of those residuals long after death, who's going to have the rights to that? And then you have people who are coming forward trying to claim that they're related to that celebrity or that decedent. Those ones that you hear about, typically they don't have kids, or they had more of a complicated family. So I would say those are probably why, plus also tax issues, and it comes with the complicated assets. The higher the complication to the assets and the taxes, the longer it's going to take to sort it all out.
Okay, that makes sense. What do you, okay, so, and my line of work, I see people just, they want to plan, but they don't. Why do you think people hold off so long and don't actually get their, estate in order or affairs in order, so that their families, don't have to go through probate or litigation?
Yeah, I think it's an easy thing to put off. There's no law that requires that anybody do any kind of estate planning. So people, even though they know it's something that they should do and it's something that's important, it's something they put off. And then eventually they just put it off too long and they didn't get to it. So I think, compared to insurance, if it wasn't a law that requires everybody to have auto insurance, I think most people wouldn't have auto insurance.
Right.
And the reason that so many people have it is purely because there's a law requiring them to do so. So I think it's that. It's something that people put on the back burner, and people get busy and they have all of these other things that they need to handle. They don't have time to get to this thing that there's nothing else that's forcing them to do it until they've gone through a situation or seen somebody else in their life go through a situation that really brings it to light for them.
Right. So is there anything you want to tell us about your, law firm, and how you approach probate litigation?
For us, this is all we do. All we handle is trust and estates. We don't do anything else. We don't do anything civil. We don't do any family law. We don't do, so we won't do divorces. We won't do any personal injury cases. All we deal with is trust and estates. So I think that's important because every county is a little bit different. We get to know our judges really well in any of these cases that we're dealing with. We know how to get things through the system. We know how to get them through quickly so that we can get it done as fast as practically possible. And we've been doing it a long time. My partner's been in this area for almost 40 years. I've been with him since 2008, and I've been an attorney for 10 years now, doing exclusively this. So I think that that's really the biggest part of it, is that this is all we do. We don't dabble in anything else. This is what we deal with day in and day out.
I love that. Well, thank you for being here. I think that was a really good talk on, what probate is and litigation and the families that, what they're dealing with, and when these disputes come up, and that they really should get their planning done ahead of time. But if they don't, then there are attorneys like you that specialize in resolving these matters as quickly as possible. I also picked up that it is really a field you have to hire an attorney that knows what they're doing. It's very specific, and there's a lot of case law and law specific to what the probate litigation law that you practice. So it's really important, if someone is going through that they pick an attorney that only handles this and knows the in and outs, particularly because it's crazy that it takes so long to get through some of the time. Really interesting. And I would love to, talk to you maybe about that Britney Spears case or a specific case down the road where, I think people don't really understand how they could lose their autonomy, if they become incapacitated, not just, just doesn't come up when someone's dying, or when someone's died, but also if you've become incapacitated. So maybe next time we could talk about that.
Yeah, absolutely. Yeah. Thank you for having me. This was fun.
If you've enjoyed today's episode, please consider subscribing to the Business Talk podcast and leaving us a review on your favorite podcast platform. Your feedback helps us grow and improve. Thank you for joining us today. This has been another episode of Business Talk with Megan McNulty.